come to this place for this occasion, I did not have any option but to accept it. But the most fundamental reason for me being with you is Dr. Jha, Dr. P.C. Jha, gave me all his students and educated many of them with his own money. The personalities, both Letviswanath Pasayar as well as of that of Dr. Chakradhar Jha, shall forever continue to inspire law students, practitioners. The topic I had selected, that was for you students only. I am reminding you, all of you, because we are having this lecture in the memory of Dr. Chakradhar Jha, who pioneered in the field of legal research in the state of Bihar. Keshawanand Bharti decision can be seen from different perspectives. I'll be explaining briefly to you, again only for the purpose of making you think over it, discuss over it, form your own opinion about what is Keshawanand Bharti. Keshawanand Bharti is a name of a person who was head of a religious mutt, who had filed a petition before the Supreme Court under Article 32 of the Constitution of India. This is simple name, Keshawanand Bharti. Keshawanand Bharti is a decision rendered by Supreme Court on the scope, the limits of constitutional amendments by the Parliament. So Keshawanand Bharti is a decision by Supreme Court. As on date, Keshawanand Bharti is a constitutional philosophy which is being debated. So these are three things. This is one aspect. The other aspect is that again you can see this decision, one can see this decision from this different perspective. As a judge, the judgment is binding. So whatever has been said by Keshawanand Bharti is the law of the land, that is binding. So for the judges, that is the limit. For the lawyers, yes, they cannot go beyond while developing their cases. They cannot go beyond presently before the High Courts what has been held in Keshawanand Bharti. For the critics of Keshawanand Bharti, they can come up with reasons why Keshawanand Bharti is incorrect, why Keshawanand Bharti is correct, why Keshawanand Bharti may require reconsideration. But you students, this is my sincere advice to you, that this Keshawanand Bharti is a thrilling topic for you to discuss and develop your own opinion irrespective of what you read in the newspapers what you find in the social media. I was just before coming to address you, I was trying to identify the historical background. Just think of the circumstances in which the law developed, the two what we call keshawanand bharti. In 1951, the first constitutional amendment was passed by the Parliament, which inserted Article 31A and 31B in the Constitution. Article 31A provided that no law providing for acquisition of states shall be deemed to be void on the ground that it is inconsistent or abridges or takes away any of the rights conferred by Article 14 or 19 of the Constitution of India. Article 31B provided that no law which is placed in the 9th schedule shall be void on the ground that they are inconsistent with Part 3 of the Constitution of India. The First Amendment was subject matter of challenge in case of Sankari Prasad Singh Dev versus the Union of India and the state of Bihar. One of the grounds for challenge was that it violated the fundamental rights and was therefore in violation of Article 13(2) of the Constitution of India. In Sankari Prasad Singh, the Supreme Court ruled that although law must ordinarily include constitutional law, there is clear demarcation between ordinary law, which is made in the exercise of legislative power, and the constitutional law, which is made in the exercise of constituent power. In the context of Article 13, law must be taken to mean the rules or regulations made in exercise of ordinary legislative power and not amendments to the Constitution made in exercise of constituent power, with the result that Article 13(2) does not affect amendments made under Article 368 of the Constitution. Now I am giving you another aspect. The strength of the Supreme Court when Sankari Prasad was decided was of 7 judges, including the Supreme Court, Chief Justice of India. And this Sankari Prasad was decided by 5 distinguished Supreme Court judges: Justice Hiralal Kania, Chief Justice, Justice M. Patanjali Sastri, Justice P.K. Mukherjee, Justice S.R. Das, Justice Chandra Shekhar Iyer. They must have assigned certain reasons. You must look into that. What reasons were assigned in Sankari Prasad? 5 judges. Thereafter, in Sajjan Singh versus State of Rajasthan, again in 1965, the question arose about the correctness of the principles enunciated in Sankari Prasad. But the apex court reiterated the power to amend the Constitution, which includes the power to amend the provisions contained in Part 3 of the Constitution. Now there is significant aspect in case of Sajjan Singh. In case of Sajjan Singh, Justice Mudholkar, J.R. Mudholkar, expressed that whether making a change in the basic structure of the Constitution would merely be an amendment, or would it amount to rewriting the Constitution. Justice M. Hidayatullah also concurred with the judgment that the writ was not maintainable but raised certain pertinent questions. I am again earnestly requesting to all the young law students interested in research in the field of law that please examine these aspects, the logics for and against. Form your own opinion. Every individual student must form his own opinion, and this can be formed only when you discuss the topic, you create platforms, you create small groups for discussing on the topic, and then form your own opinion independent of the opinions maybe by the Supreme. We don't know which law student of this college will become Hiralal Kania, Patanjali Sastri, and can have his own views, can add to the development in the field of law. Therefore, I am repeatedly attempting to trigger your mind so that you may come with reasons, develop your reasons. Now, in Sachin Singh was also decided by 5 judges, Justice P.V. Gajendra Katkar, CJ, K.N. Vanchu, Justice M. Hidayatullah, Justice Raghuvar Dayal, Justice J.R. Mudholkar. Thereafter, the Supreme Court in case of Golaknath versus State of Punjab held that there is no distinction between ordinary law and constitutional amendment, and therefore legislature cannot by any constitutional amendment abridge or take any of the rights guaranteed under Part 3 of the Constitution. Golaknath case was decided by 11 judges. 6, it was a majority view that prevailed. Majority of 6 with 5 dissenting. And who were those 6 judges? Justice K. Subba Rao, Justice J.C. Shah, Justice James Sikri, Justice James Shillar, Justice C.A. Vaidyanathan, Justice M. Hidayatullah. And who dissented? Justice K.S. Vanchu, Justice Visastra Bhargava, Justice G.K. Mittal, Justice R.S. Bachawar, Justice V. Ramaswamy. 6:5. Then what happened? In 1963, the government of Kerala passed the Kerala Law Reforms Act 1963, and the properties of various religious institutions got affected, including that of the religious mutt headed by which name? Keshawanand Bharti is her name, and now a constitutional philosophy. He challenged the validity of Kerala Land Reforms Act 1963. In the meantime, the Government of India passed the 29th Amendment and included some of the land reforms in the 9th Schedule. The constitutional validity of 29th Amendment Act as well as 24th and 25th Amendment Act was also challenged by Keshawanand Bharti. The amendment added a clause 4 in Article 13 which provided that nothing in Article 13 would apply to any amendment in the Constitution made under Article 368. The amendment was brought about to nullify the effect of Golaknath case. Article 368 was also amended and Clause 3 was added to the article which provided that nothing in the Article 13 shall apply to an amendment made under Article 368. Keshawanand Bharti is a final decision as on date that basic structure of the Constitution cannot be changed. I call upon you, all the law students, to ponder over what is basic structure. The structure of a building what is basic in that, in the building, whether it is the foundation, whether it is the plinth area, whether it is the walls which are constructed, whether the roof, whether the pillars, what is not permitted to be changed in the light of the decision rendered by Supreme Court, you need to ponder over. Because what is the basic structure has still not been finally defined. So think over. In case of L. Chandra Kumar, the Supreme Court said that Article 226, the power of judicial review of the High Courts, is basic structure of the Constitution. So this is how the law of basic structure of the Constitution is evolving. Therefore, and then what happened in Keshawanand Bharti, which we follow, this was decided by 13 judges. Keshawanand Bharti is a decision of 13 judges, 6 dissenting. Why did they dissent? So therefore, my dear students, if you need to understand, if you need to grow in this field of law, because Keshawanand Bharti, you will have to encounter, you will have to deal with, you will have to address the issues arising out of this on various occasions when you participate in any seminar, or when you develop your own concept, or when you go into the field of research or teaching or whatever, so many. Keshawanand Bharti is said basic structure doctrine was laid down by a razor thin majority, 7-6. Therefore, in the beginning, I told you that Keshawanand Bharti can be seen. It has a judge has no other option but to accept it. It is the law of the land. But you students, think over it, form your own opinion, evolve your own. I would request the principal of the law college to create a situation, to create a system where some certain groups of law students are formed to discuss these burning topics. Madam Mridula Mishra referred to a very recent decision of the Supreme Court and the criticism which has come in one of the newspapers today. The Supreme Court's decisions are binding on us, everyone's law of the land. But that will not bind your mind. You can think beyond that. And once you start thinking from this stage, then only, in my opinion, you can have a sound foundation.